Section 51(1) provides, "The Parliament shall, subject to this Constitution, have power to make laws for the peace, order, and good government of the Commonwealth, with respect to trade and commerce with other countries and among the states." This lecture is about the way in which the High Court has interpreted the trade and commerce power. I will first provide some background information about the trade and commerce power. I will then set out how the High Court has interpreted the separate phrases trade and commerce and with other countries and among the states. Then I will discuss several kinds of laws that have been held to be with respect to trade and commerce with other countries and among the states. Finally, I will explain the extent to which the Commonwealth Parliament may regulate intra as opposed to inter state trade and commerce in reliance upon the trade and commerce power. The regulation of trade and commerce with other countries and among the colonies was, along with defence, one of the primary motives for federation. The very first draft of an Australian Constitution, which was prepared by Andrew Inglis Clark in 1891, conferred power upon the Parliament to regulate commerce and trade with other countries and among the several provinces. The placement of trade and commerce at the top of the list of Commonwealth powers was not an accident. The trade and commerce power is one of several economic powers contained in Section 51 of the Constitution. Other examples include the corporation's power, the industrial arbitration power, the banking power, and the insurance power. These powers give the Commonwealth Parliament substantial control over economic activity throughout the country, but they must be read alongside the provisions of Chapter 4 of the Constitution. Chapter 4 contains provisions relating to finance and trade. One significant provision, for relevant purposes, is Section 98. Section 98 provides, "The power of the Parliament to make laws with respect to trade and commerce extends to navigation and shipping, and to railways the property of any state." The most significant provision in Chapter 4, however, is Section 92. Section 92 provides that trade, commerce, and intercourse among the states, whether by means of internal carriage or ocean navigation, shall be absolutely free. No other phrase in the Constitution has caused as much consternation as the words "absolutely free" in Section 92. Fortunately, that consternation is outside the scope of this lecture. The first issue relevant to the interpretation of the trade and commerce power is the meaning of the words trade and commerce. What does trade and commerce mean? In MacArthur, WA Ltd in Queensland, Chief Justice Knox and Justices Isaacs and Stark said that the words trade and commerce were not terms of art, but rather terms of common knowledge as well known to laymen as to lawyers, and better understood in detail by traders and commercial men than by judges. This does not really provide a definition, but their honours had a point. The words are broad and tend to encompass everything that an ordinary person would consider to be trade and commerce, such as the buying and selling of goods, the transportation of goods, and the provision of services for reward. For that reason, the real limitation upon the scope of the power derives from the words that follow trade and commerce, with other countries and among the states. The words with other countries and among the states do not refer only to trade and commerce between the Commonwealth and other countries, or between the states themselves. That is, they do not relate only to, for example, the state of New South Wales trading with the state of Queensland. They relate primarily to trade and commerce conducted by Australian citizens, to trade and commerce between citizens resident in different states, and between Australian citizens and citizens of other nations. The words with other countries and among the states are words of limitation. They limit the reach of Commonwealth legislative power, but they are only a limited limitation. As Chief Justice Barwick said in Strickland and Rocklip Concrete Pipes Limited, the trade and commerce power contains no explicit or implicit prohibition and does not reserve the subject of intrastate trade to the states. By this the Chief Justice meant the words with other countries and among the states limit only the words trade and commerce in the trade and commerce power. They prevent the Commonwealth Parliament from making laws with respect to trade and commerce within the borders of one state in reliance upon the trade and commerce power, but they do not prevent the Commonwealth Parliament from making laws that affect trade and commerce within the borders of one state in reliance upon its other powers. If the Commonwealth enacted laws with respect to weights and measures pursuant to its power to make laws With respect to weights and measures in section 51(15) of the Constitution, for example, no state could argue that the laws are invalid insofar as they affect weights and measures used in intrastate trade and commerce. I hope that makes sense. What I have just said deals with the meaning of the separate phrases trade and commerce and with other countries and among the states. I will now turn to the more significant issue of the meaning of those two phrases strung together. I'm going to discuss several kinds of laws that the High Court has held comes within the scope of trade and commerce with other countries and among the states. Then I am going to deal with the tricky question of when, if ever, the Commonwealth Parliament can make laws that touch intrastate trade and commerce in reliance upon the trade and commerce power. Earlier, I quoted from the MacArthur case, in which Chief Justice Knox and Justices Isaacs and Stark said that the words trade and commerce were not terms of art. In that case, the High Court rejected an argument that the words trade and commerce were confined to the act of transporting goods across state borders. That decision is also authority for the proposition that the trade and commerce power encompasses the act of transportation of goods across borders for profit, as well as the commercial arrangements necessary to conduct that transportation. Chief Justice Knox, Justices Isaac and Stark said, in relation to foreign trade and commerce in particular, trade and commerce between different countries has never been confined to the mere act of transportation of merchandise over the frontier. That the words include that act is, of course, a truism, but that they go far beyond it is a fact quite as undoubted. All the commercial arrangements of which transportation is the direct and necessary result form part of trade and commerce. The mutual communings, the negotiations, verbal and by correspondence, the bargain, the transport, and the delivery are all, but not exclusively, parts of that class of relations between mankind, which the world calls trade and commerce. This principle was extended to the transmission of intangible goods in the bank nationalisation case. In that case, Justice Dixon said that the transmission of money from one bank in one state to another bank in another state was trade and commerce between the two states. The Privy Council expressly endorsed his view on appeal. The High Court has held that the Commonwealth may rely on the trade and commerce power to enact laws pursuant to which it itself engages in trade and commerce. The authority for this proposition is Australian National Airways and the Commonwealth. To put things in context, the Wright brothers first achieved flight in 1903, but by the 1930s there were a multitude of private commercial airlines competing throughout Australia, and by the 1940s an airline known as Australian National Airways had achieved a monopoly hold on domestic Australian flights. The government responded by enacting the Australian National Airlines Act in 1945. Section 6 provided for the establishment of the Australian National Airlines Commission. This was a body corporate that would conduct commercial interstate air transportation. Australian National Airways, the monopolist, challenged the constitutional validity of the legislation. It argued that the trade and commerce power did not empower the Commonwealth to make laws pursuant to which it itself would engage in trade and commerce. The High Court rejected that argument. Justice Dixon said, a law authorizing the government to conduct transport service for interstate trade, whether as a monopoly or not, appears to me to answer the description, a law with respect to trade and commerce amongst the states. It is only by importing a limitation into the descriptive words of the power that such a law can be excluded. This decision is authority for the proposition that the Commonwealth can rely upon the trade and commerce power to make laws that provide for it itself to engage in interstate trade and commerce. However, it does not support the proposition that the Commonwealth can make laws to confer upon itself a monopoly, despite the quote from Justice Dixon I just read. That is because the High Court held that the Airlines Act, to the extent that it purported to confer a monopoly on the Commonwealth, contravened Section 92 of the Constitution, which I read before. Trade, commerce, and intercourse among the states, whether by means of internal carriage or ocean navigation, shall be absolutely free. The High Court has held that the Parliament may rely upon the trade and commerce power to prohibit the export of particular goods. The authority for this proposition is Murphy Oars and the Commonwealth. Murphy Oars held a mining lease issued by the Queensland Government over Fraser Island. Commonwealth regulations prohibited the export of zircon and rutile from Australia except with approval of a Commonwealth minister. Murphy-Oors applied for approval. The minister rejected his application on the ground that mining would damage the environment on Fraser Island. Murphy-Oors commenced proceedings in the High Court. It argued that the minister could not consider environmental protection when deciding whether to approve an application. The High Court rejected this argument. It held that, as the regulations were with respect to trade and commerce with other countries, the motives behind the particular criteria for export were not relevant. This case is authority for the proposition that the Commonwealth may prohibit export of goods from Australia for whatever reasons it deems fit, pursuant to the trade and commerce power. The High Court has held that Parliament may rely upon the trade and commerce power to regulate the employment of workers by businesses engaged in interstate and foreign trade and commerce. The authority is Huddart Parker Ltd and the Commonwealth. The Transport Workers Act of 1928 empowered the Governor-General to regulate the shipping industry. The Governor-General issued a regulation that required employers to prioritise the employment of members of the Waterside Workers' Federation on overseas and interstate vessels. Huddart Parker challenged the validity of the legislation on several grounds. One ground was that the regulation was beyond the scope of Commonwealth legislative power. The High Court rejected that argument. It held that the regulation was valid insofar as it affected those working for businesses conducting interstate or foreign trade and commerce. The High Court reaffirmed that proposition in the more recent case of Re Maritime Union, ex parte CSL Pacific. It held that Parliament can validly regulate the conduct of persons employed in those activities which form part of trade and commerce with other countries and among the states. The proposition that the power extends to regulation of workers may logically be extended to encompass other aspects of businesses that are engaged in interstate and foreign trade or commerce. The High Court has held that the Commonwealth Parliament can rely on the trade and commerce power to make laws with respect to the production and manufacture of goods. This is one of the more difficult and controversial aspects of the power, so I will spend some more time on it. The judges in the MacArthur case, when they defined trade and commerce, spoke of mutual communings, negotiations, bargains, transport, and delivery. But they did not speak of production, nor did they speak of manufacture. That is because the production and manufacture of goods precedes trade and commerce. The goods must be made before they can be traded. The High Court recognized this basic fact in Beale and Marrickville Margarine. Marrickville Margarine argued that New South Wales could not regulate the production of margarine intended solely for interstate trade due to Section 92 of the Constitution. Trade, commerce, and intercourse among the states shall be absolutely free. The High Court rejected that argument. Justice McTiernan said, "It was necessary for the goods to be made before the trade in them began. It cannot be correct to say that the manufacture was part of such trade." And Justice Kiddo said similarly, even where a specific batch of material can be identified in the factory as being in course of manufacture for the specific purpose of being applied to fulfillment of a specific contract with a buyer in another state, it is not logically possible to affirm that any trade in respect of that material or any interstate movement has begun. These statements are what make the extension of the trade and commerce power to the production and manufacture of goods controversial. The High Court held in Beale and Marrickville Margarine that production and manufacture was not trade and commerce. So how is it that the High Court has held that Parliament can rely on the trade and commerce power to make laws regulating production? The two positions appear to be inconsistent, but the apparent inconsistency is explainable. The starting point for the explanation is the authority on laws regulating production under the trade and commerce power. That authority is O'Sullivan and no longer meet. The Commonwealth issued regulations that prohibited the exportation of meat unless the premises used for treatment and storage met certain health requirements. The regulations also required that all premises used for the slaughter of meat be registered. The regulations were challenged in part on the ground that regulation of production was beyond the scope of the trade and commerce power. The High Court rejected that argument. Justice Fulliger said, "It is true that the Commonwealth possesses no specific power with respect to slaughterhouses, but it is undeniable that the power with respect to trade and commerce with other countries includes a power to make provision for the condition and quality of meat or of any other commodity to be exported. Nor can the power, in my opinion, be held to stop there. By virtue of that power, all matters which may affect beneficially or adversely the export trade of Australia in any commodity produced or manufactured in Australia must be the legitimate concern of the Commonwealth. Such matters include not only grade and quality of goods, but packing, get-up, description, labeling, handling, and anything at all that may reasonably be considered likely to affect an export market by developing it or impairing it. He continued, it seems clear enough that the objectives for which the power is conferred may be impossible of achievement by means of a mere prescription of standards for export and the institution of a system of inspection at the point of export. It may very reasonably be thought necessary to go further back, and even to enter the factory or the field or the mine. How far back the Commonwealth may constitutionally go is a question which need not now be considered, and which must in any case depend upon the particular circumstances attending the production or manufacture of particular commodities. But I would think it safe to say that the power of the Commonwealth extended to the supervision and control of all acts or processes which can be identified as being done or carried out for export. Chief Justice Dixon, Justices McTiernan and Kitto agreed with Justice Fulliger on this point. The decision is authority for the proposition that the trade and commerce power empowers the Commonwealth to make laws with respect to the production of goods intended for interstate and foreign trade, to legislate back up the chain of supply, so to speak. As I mentioned earlier, it appears to conflict with Beale and Marrickville margarine, the case in which the High Court held that production does not constitute trade or commerce. The Noarlunga meat case can be reconciled with Beale and Marrickville margarine because Section 51 contains a grant of power to make laws with respect to trade and commerce. In contrast, the limitation in Section 92 does not contain the words with respect to. It simply provides trade, commerce, and intercourse among the states, whether by means of internal carriage or ocean navigation, shall be absolutely free. The authority in relation to the significance of the words with respect to is another case involving the Marrickville Margarine Company, Granel and Marrickville Margarine. Chief Justice Dixon and Justices McTiernan, Webb, and Kitto explained why the trade and commerce power may extend to control, production, or manufacture. In the first place, the power is to legislate with respect to trade and commerce. The words with respect to ought never be neglected in considering the extent of the legislative power conferred by Section 51 or Section 52, for what they require is a relevance to or connection with the subject assigned to the Commonwealth Parliament. In the next place, every legislative power carries with it authority to legislate in relation to acts, matters, and things, the control of which is found necessary to effectuate its main purpose, and thus carries with it power to make laws governing or affecting many matters that are incidental or ancillary to the subject matter. The words incidental and ancillary to are important. The power to make laws in Section 51 extends to matters incidental and ancillary to the subject matter of the laws themselves. I will address the notion of laws that are incidental or ancillary to grants of power in the next lecture, which concerns characterization of Commonwealth laws. The Noarlunga case is authority for the proposition that the Commonwealth may legislate back up the chain of supply. But what about the opposite proposition? Can the Commonwealth legislate down the chain and make laws with respect to the sale of goods to consumers, as opposed to the trade and delivery of goods between manufacturers, wholesalers, and retailers? The High Court considered that question in Crowe and the Commonwealth. The Commonwealth Dried Fruit Export Control Act provided for the regulation of the sale and distribution of dried fruit exported from Australia. William Crowe was a fruit merchant who exported and sold fruits in the United Kingdom, Canada, and New Zealand. He argued that the Act was invalid on the ground that the trade and commerce power did not empower the Commonwealth to regulate the sale of goods overseas, that the words with other countries did not mean in other countries. The High Court rejected that argument. Justice Dixon held that the Commonwealth's authority over export was complete. Justices Evatt and McTiernan said, the sale and marketing of the goods abroad constitutes a typical and essential part of international trade. The decision is authority for the proposition that the trade and commerce power extends to the conditions under which exported goods may be sold. It should be possible to argue by extension that it also extends to the conditions under which goods traded interstate may be sold. I have now covered the main circumstances in which the Commonwealth Parliament may make laws pursuant to the trade and commerce power with respect to international and foreign trade and commerce. The remainder of the lecture concerns a trickier issue: the extent to which the trade and commerce power empowers the Parliament to make laws that, in the course of regulating interstate trade and commerce, also regulate intrastate trade and commerce. The starting point for this issue is that the trade and commerce power clearly does not permit the Commonwealth Parliament to make laws directed solely at intrastate trade and commerce. That is the effect of the words "with other countries and among the states." They limit the Commonwealth Parliament to making laws with respect only to interstate and foreign trade and commerce. The general rule is that a law that purports to regulate intrastate trade and commerce is invalid. What I am about to discuss is an exception to that general rule. This exception bends the literal meaning of the text and is best explained by discussing the cases across which it developed. The central authority on the topic is Re Burgess ex parte Henry. Section 4 of the Air Navigation Act 1920 provided for the making of regulations for the control of air navigation in the Commonwealth and the Territories. The Commonwealth argued that it was necessary to control all air navigation, including intrastate air traffic, in order to promote the safety of international and interstate air navigation. The High Court rejected that argument. Chief Justice Latham said, "On several occasions the argument has been pressed upon this court that, where interstate or foreign and intrastate maritime trade and commerce are so intermingled that it is practically essential to control all of them as one subject matter, the Commonwealth Parliament has power, under the trade and commerce power, to deal with intrastate navigation and shipping." The decisions of this court, however, have definitely declined to adopt such a position, and have therefore left the problem, which is indicated by the illustrations above given, to be solved by some form of cooperation between the Commonwealth and the states. In other words, the Chief Justice held that the Commonwealth could not regulate intrastate trade and commerce simply because intrastate trade and commerce was intermingled with interstate or international trade and commerce. However, the Chief Justice also said, "A new problem would be raised if in any given case it were established by evidence in respect of a particular subject matter that the intermingling of foreign and interstate trade and commerce with intrastate trade and commerce was such that it was impossible for the Commonwealth Parliament to regulate the former without also directly regulating the latter." This was a hint that the trade and commerce power could be used to regulate intrastate trade and commerce where it would otherwise be impossible to regulate interstate and international trade and commerce. The hint set a high threshold for the regulation of intrastate trade and commerce for what is truly impossible. This high threshold was lowered slightly by later cases. The first move towards lowering the threshold came in Swift Australian Co. Pty Ltd and Boyd Parkinson. The Commonwealth issued regulations that required registration of establishments used for the slaughter, treatment and storage of meat for export. Swift operated a poultry killing and processing plant in Queensland. About 5% of its output was exported from Australia. The rest was sold in Queensland or interstate. The plant was registered under the Commonwealth regulations, but it was not registered under the Queensland Poultry Industry Act. Swift was prosecuted for breaching the Queensland Act. It attempted to argue that the Queensland Act was invalid because it was inconsistent with the Commonwealth regulations. One issue in the case was the extent to which the Commonwealth regulations, which extended to meat intended for export, also captured meat intended to be sold within Queensland. Only 4 judges referred to that issue. Swift had argued that because it commingled poultry intended for export with poultry intended for internal sale, the Commonwealth regulations necessarily encompassed its entire plant. Justice McTiernan rejected that argument, but Justices Menzies, Taylor and Owen did not. Justice Menzies said that the trade and commerce power could be used to regulate, in an establishment that slaughtering export is carried on in the interest of overseas trade, operations not directly concerned with preparing goods for the trade. but he did not elaborate. Justice Taylor was more equivocal. He said it may be that pursuant to its legislative power, the Commonwealth might forbid slaughtering for home consumption in an establishment registered under the Commonwealth regulations. Justice Owen, however, who dissented from the majority, said that it was undeniable that the trade and commerce power was wide enough to regulate the entire plant. To begin with, it is difficult to imagine a state of affairs in which slaughter, treatment, storage, and packing of meat for export is carried on in an establishment and the whole of the meat products resulting from those operations is ultimately exported. There must inevitably be some meat which, for a diversity of reasons, may be rejected for export, yet be entirely suitable for home consumption. Again, as the facts of the present case show, it may be impossible to predicate at the time of slaughter, treatment, storage, or packing whether any particular carcass or any particular part of the carcass will ultimately be exported or whether it will go into home consumption. Finally, if the slaughter, treatment, or storage or packing of meat for export is carried on in the same establishment as the slaughter of meat for home consumption, it may well be necessary that the whole of the operations carried on in the establishment should be governed by the set of regulations which are directed to the preparation of meat for export, lest the condition or quality of meat which finally goes into export be prejudicially affected by the conditions under which the slaughter of meat for the home market takes place. This statement does not represent binding law, but it is an example of one judge attempting to drag the interpretation of the trade and commerce power away from the strict delineation between interstate and foreign trade and commerce on the one hand and intrastate trade and commerce on the other. The next case was Redfern and Dunlop Rubber Australia. The Australian Industries Preservation Act prohibited businesses from entering into contracts in restraint of trade or commerce. The defendants were manufacturers of motor vehicle tyres. They had entered into an agreement pursuant to which they agreed not to supply their products to certain retailers. As some of the defendants were located in the same states as the retailers, they argued that the agreement related to intrastate trade and was therefore beyond the reach of the Industries Preservation Act, which was enacted in reliance upon the trade and commerce power. The High Court rejected that argument, on the ground that the agreement itself combined overseas, interstate, and intrastate trade. This made regulation of its intrastate aspects inseparably connected with interstate trade and commerce. The next case relevant to the ability of the Commonwealth to make laws with respect to intrastate trade and commerce was Airlines of New South Wales and New South Wales Number 2. The Commonwealth Government issued regulations that required all commercial aircraft within the Commonwealth to be licensed, including those that flew only intrastate flights. The regulations provided that the Director General was to have regard to matters concerned with the safety, regularity, and efficiency of air navigation and to no other matters when determining whether to issue a license. The High Court held the regulations to be valid. This was a departure from its previous decision in Ex parte Henry. Justice Kitto said, where the intrastate activities, if the law were not to extend to them, would or might have a prejudicial effect upon matters merely consequential upon the conduct of an activity within federal power, e.g., whether profit or loss likely to result from interstate commercial air navigation would or might be affected, that mere fact would not suffice, in my judgment, to make the law a law with respect to that activity itself. But, by contrast, where the law, by what it does in relation to intrastate activities, protects against danger of physical interference with the very activity itself, which is within federal power, the conclusion does not seem to me to be correct that in that application, the law is a law within the grant of federal power. This statement is often referred to as authority for the proposition that the trade and commerce power may be used to regulate intrastate trade and commerce to protect interstate and foreign trade and commerce against physical interference. However, from another perspective, it relates to the kind of impossibility that Chief Justice Latham refused to recognize in Ex parte Henry. That is apparent if one takes into account what Justice Kitto said next. The significance of distances of geographical relationship is necessarily different for a problem concerning air navigation than for a problem concerning any other form of transport. With all this in mind, It is impossible to assume in advance that any impairment of the safety, regularity, or efficiency of intrastate air navigation will leave unimpaired the safety, regularity, and efficiency of the other departments into which their navigation may be divided for constitutional purposes. When this statement is taken into account, it appears that Justice Kitto was not necessarily rejecting the principle that the Commonwealth may only regulate intrastate trade and commerce when it is otherwise impossible to regulate interstate trade and commerce. Rather, he was rejecting Chief Justice Latham's particular application of that principle, i.e., the assertion that it is possible to regulate interstate and foreign air navigation without regulating intrastate air navigation. This leaves the threshold of impossibility intact, but at the same time, it demonstrates that the High Court has not treated the word impossible as having its literal meaning. The other cases we have discussed support this proposition. In Swift and Boyd Parkinson, Justice Owen explained that it may be necessary to regulate the preparation of products intended for interstate trade where they are manufactured in the same plant as products intended for interstate trade or export. This can be interpreted as an application of the principle in Ex parte Henry, as an assertion that, in practice, it is impossible to apply different standards to the same products manufactured in the same plant. Similarly, in Redfern and Dunlop Rubber, the High Court treated the agreement between the tyre manufacturers as within the reach of the law enacted pursuant to the Trade and Commerce Power because the agreement itself conflated interstate and intrastate trade. It was not possible for the law to distinguish between them because the agreement itself had conflated them. The only alternative would have been to hold that any agreement with an intrastate component was beyond the reach of the Australian Industries Preservation Act, which would have allowed national cartels like the tyre manufacturers to evade liability. My point here is that the authorities are not necessarily contradictory. They have simply stretched the meaning of the word impossible to mean something more like extremely impracticable. The final case relevant to this topic provides an indication of just how far the High Court has been willing to stretch that meaning. The case is Attorney General of Western Australia, ex-Rail Ansett Transport Industries Operations, and Australian National Airlines Commission. The Australian National Airlines Commission operated an airline under the name Trans-Australia Airlines. The Commonwealth amended the Australian National Airlines Act to empower the Commission, for the purposes of the efficient, competitive and profitable conduct of its business, to run intrastate flights. Ansett argued that this was beyond its power under the Trade and Commerce Power. Chief Justice Barwick and Justices Stephen and Gibbs formed a majority to hold the legislation to be invalid so far as it relied upon the Trade and Commerce Power. They emphasised that the Commonwealth could not rely upon economic or commercial considerations to justify regulation of intrastate trading activities. These considerations fall far below the impossibility or extreme impracticability that was present in Redfern and Dunlop Rubber and the Airlines of New South Wales cases. However, for completeness, I should note that Justices Stephen, Murphy and Mason formed a different majority on a separate issue. That issue concerned whether the legislation was valid under the Territories' power in Section 122 of the Constitution. Their Honours held that it was valid under that power, but only to the extent that it promoted the efficient, competitive and profitable conduct of territorial air services.